The code has been drafted in accordance with Article 40 of the GDPR. Article 40 states that member states, data protection authorities, and the European Commission shall encourage the drawing up of codes of conduct intended to contribute to the proper application of the GDPR, taking into account the specific features of various sectors. Codes of conduct should be prepared by associations or bodies which are representatives of the sector. This is a responsibility initiative of the gambling sector to improve data protection standards, same as we did, as you may know, for the advertising code of conduct. In order to prepare this code, we created a working group composed by the data protection officers of EGBA members. And further, we also held a public consultation on the code between January and February this year, to which any interested stakeholder could submit comments. We asked also a law firm to carry out an independent review of the code. So the code has been developed in the context of the citizens' concern about their data in the online world. And this is one of the reasons why we decided to create this code. In the next slide, we talk about the scope of the code. So first, the code applies to all EGBA members and is open for adherence to any other online gambling operator. Other gambling companies can sign up to the code even before its approval. When drafting the code, we had to bear in mind that this code should be accessible also for smaller operators. This is because the GDPR and the guidelines on codes of conduct mention explicitly that every code has to take into account the possibilities of small and medium companies to join that code. The code covers all types of processing of personal data of customers in the online gambling sector and does not cover the company-employee relationship in the companies themselves or offline activities. The code will apply in all EU and EEA countries. Nonetheless, gambling companies outside the EU and EEA can decide to adhere to the code. Of course, their compliance will be monitored in the same way as for all other signatories. In the next slide, we cover adherence and promotion. The code, as we said, is open for adherence by other gambling operators upon the payment of an administration fee to cover the monitoring costs. This fee will mostly be used to guarantee the independence and the work of the monitoring body. On this, we will come back later. National gambling associations are also invited to endorse the code and to encourage their members to sign up to it. Already the Dutch National Association expressed interest in endorsing the code, and they will probably do this next week. Finally, the code is a living document and will be further developed over time, following legislative or technological developments on data protection. The code will also be amended in case we see that when we apply it in practice, there are certain practical problems arising. In the next slide, we mention the objectives of the code. First of all, it has to be reminded that adhering to an approved sectoral code of conduct is a factor when demonstrating a company's compliance with the GDPR, and is taken into account by the relevant national data protection authority when deciding on enforcement actions for breaching the GDPR. This includes, for example, reducing the amount of fines, which for the GDPR can go up to millions of euros. So the code aims to achieve three objectives. The first one is to provide guidance to online gambling companies on how to apply the GDPR. This is because the sector, as you know very well, is covered by different national laws and licensing requirements, which sometimes may collide with the GDPR. So we wanted to offer a guidance to all gambling companies on data protection. The second objective is to foster trust with customers and improve transparency on how their data is used. We know very well from the news that failing to protect customers' data can bring loss of reputation for the companies. And EGBA members want players to know that their data is protected and it's used in a transparent way. Finally, this is a pan-European initiative that will assist online gambling companies in achieving an harmonized application of the GDPR, taking into account the specificity of the online gambling sector. And this will be useful for companies, for data protection authorities, and other regulatory authorities. Now, let's go a bit more into the details on the content of the code with some examples of its measures. In the next slide, we see these measures. The code introduces essential sector-specific rules and best practices to ensure the highest standard in data protection and GDPR compliance for the online gambling sector. Following the code, operators must create a data map, which can be done in one or more documents. The data map will help operators to understand precisely what personal data they process, for what purpose the data is used, the source of the data, the location of the data in the systems of the operators, how personal data moves inside and outside of the company. And all these requirements go further than what is required by the GDPR in their article of records of processing. As you know, a legal basis to process personal data is consent. In the code, we established detailed requirements on how consent can be required to the player. For example, consent must be given through an active motion or declaration. Operators cannot require consent as a prerequisite to use their services. Any request for consent must be separate from any other contractual clauses or other privacy policy provision, and this needs to be very clear for the player. And finally, customers should also have the possibility to easily withdraw consent at any time they wish. In order to do all of this, operators must establish a consent management process. This will help them to easily demonstrate when consents are collected, in which form they are collected, for which processing activity, and when this consent is withdrawn. Another legal basis is the legitimate interest one. Legitimate interest refers to the operator's own interest or the interest of third parties. They can be commercial interests, individual interests, or even wider societal considerations. Operators can rely on this legal basis only if they conduct a legitimate interest assessment. To do this, operators shall possess appropriate legitimate interest assessment templates and processes, and these have to include details on the personal data that will be processed. It has to explain why the processing is necessary and proportionate to achieve the legitimate interest in question, how the risk for personal data will be managed, and of course, considerations on the player's interests, their rights and freedoms have always to be taken into account. Then we have a section on the transparency in the code. This section specifies what needs to be contained in a company's privacy policy and which are the possible exceptions to the transparency principle in view of the specificities of our sector. For example, operators cannot communicate to the players any suspicions or investigations on money laundering, because this will hinder the investigation itself. The same applies for certain processing of data which is done to fulfill responsible gambling provisions. If the player knows how to bypass the checks for patterns of problem gambling, then he will not be protected against the risk of problem gambling. So, in certain cases, the logic behind the actions put in place by the operators to protect players and to comply with other legal obligations will not be explained in detail to the players themselves. In the next slide, we cover data retention. Operators must develop a data retention policy and identify the different periods personal data is kept for, in respect of each processing activity. When the law gives them discretion to define the retention period, operators must possess a justification for this. This is especially important, for example, regarding anti-money laundering laws, because in certain countries, these laws define a minimum period to retain customers' data. But this can change from country to country, so operators need to be aware of this. Of course, when the relevant period for keeping the data has been reached, the data should be deleted or anonymized. The code covers all the rights of players regarding data protection, and to give an example, there is the data portability right. This right allows for customers to receive a copy of their personal data in order to send it to another operator. Or they can also ask directly to the gambling company to transfer their data to another company. The decision on this will always rest on the player, and in order to simplify things, we allow in the code the possibility for gambling operators to contact the other company and determine together precisely which types of data are required by the latter and in which format. The code covers also automated decision making. This is the ability to make decisions by technological means based on data provided directly by the customers or data observed or inferred about customers. In this case, there needs to be a balance between the obligation to provide players with information on the use of automated decision making, including profiling, with other legal obligations. For example, in the case of profiling for fraud or crime prevention purposes, as well as for players' protection, operators cannot provide players with the logic behind this, because that would enable players to bypass the controls put in place by the companies. Then we have a section on data transfers, which contains rules on transfers both to other controllers, for example, sports bodies, gambling regulators, or the police. And in this case, it's important to notice that usually the law will provide a lawful basis for this processing, for this transfer. Nonetheless, whoever requests data to operators has to explain the reasons for the request and the details on which data is requested. We also cover rules on how to manage the relationship with processors. Processors are those companies that process data on behalf of the controller. They could be, for example, payment service providers. In this case, operators need to carry out a due diligence assessment of data processors to check if they guarantee compliance with the GDPR and the relevant security measures. Further, operators must have in place appropriate data processing agreements with the processors. These agreements should outline different rules, like, among others, what processing operations will be conducted by the processors, the security commitment on the part of the processor. In the next slide, we talk about personal data breaches. Online gambling companies are required to introduce a plan to prevent and mitigate breaches of personal data. The plan will include procedures for identifying, categorizing, and communicating, if needed, personal data breaches. In certain cases, there may be need to notify the relevant data protection authority or even the players themselves, depending on the risk posed by the breach to their rights and freedoms. This is very important, as we said, because failure to protect personal data can easily bring to loss of customers' trust. In the code section on security measures, we offer a detailed guidance on how to adopt a risk-based approach to security measures. The code mentions specific security measures like encryption or pseudonymization of personal data. We also allow the possibility for operators to use certifications as a part of demonstrating compliance with the security obligations. For example, the ISO 27001. The code also offers guidance on how to guarantee confidentiality, integrity, and the availability of data. This means that data has to be protected from unauthorized access or disclosure. Data cannot be modified in an unauthorized manner, and it has to be ensured that personal data is available when needed. The code has, of course, a section on data protection impact assessment. Operators shall conduct a data protection impact assessment before beginning any type of processing, which is likely to result in a high risk for the players. The purpose of conducting a data protection impact assessment is first to identify any potential risks to players' personal data, and then for each risk is identified, the operator will determine and implement measures to appropriately manage those risks. For example, this may bring the operator to decide to not proceed with an activity that gives rise to a high risk. Finally, the code also covers the relationship with data protection authorities. Since online gambling operators usually offer their services in different member states, they must designate their main establishment and document the identification of their lead data protection authority. The main establishment can be determined as either the place of the operator's central administration in the European Union, or it can be the place where the decisions on the purposes of the processing of personal data are taken. Moreover, we indicated also how operators have to respond to data protection authorities' requests. For example, when they request to operators their data processing records. In the end, the cumulative effect of all these measures I just mentioned will be that customers' data is protected, companies will have a clear way on how to apply the GDPR, and regulators will be sure that gambling companies meet high data protection standards. So, we mentioned measures, and now I want also to give you some examples on how the code works in practice. In the next slides, we see a description of the case studies. Following the public consultation, we decided to include in the code certain case studies to offer to gambling companies practical guidance on what must be considered on the data protection side in certain sector-specific situations. There are 5 case studies in the code. The first one is on VIP. When an operator decides to set up a VIP scheme for certain players, the operator will first use profiling to assess if a player qualifies for a VIP scheme. This will be done generally using the legitimate interest legal basis, for which the requirements in the legitimate interest section apply. Further, the gambling companies should give additional privacy training to VIP account managers, since it's likely that the VIP players will share more personal data than other players, and therefore there should be appropriate security measures in place, for example, on who can access the data of VIP. The second case study is on problem gambling. It has to be noted that operators are usually subject to license conditions and regulatory requirements that oblige them to identify patterns of potential problem gambling. And of course, they have also to ensure they have a self-exclusion program in place to protect the players. The case study covers which lawful basis can be used to process data on problem gambling. Usually, it will be compliance with a legal requirement, or can be also a public interest. Further, the data used to identify problem gambling shall also be secure. Even if it's not considered a special category of data, it will be still private and sensitive for the players. The case study also covers how to share data with gambling regulators. This can be done only when sharing is necessary and proportionate, and there is a lawful basis for it. Finally, usually, operators will use automated decision-making technology in assessing potentially vulnerable patterns of problem gambling. In this case, it has to be ensured there is human involvement when taking decisions that may have a significant effect on a player. In the next slide, we see the third case study on direct marketing. Operators, in this case, have to take into account certain issues. Operators may have various brands, and in this case, they should make very clear to players from which brands they will receive marketing. And of course, they always have to allow customers to unsubscribe from receiving marketing. Another important issue is that in countries that have self-exclusion registers, self-excluded players should never receive any direct marketing. As soon as a player has a self-exclusion status, he shall not be receiving any kind of marketing by any means. Operators will also need to consider the specific rules on direct marketing by electronic means set out in local legislation. It's possible that, depending from the country, gambling companies will need to have a different approach on this issue. Another case study is on the obligation to prevent fraud. Even if this is established in the law, there must always be a balance with the privacy rights of the players. Therefore, operators should identify a legal basis, which, if it's not the law, will be legitimate interest. And operators may also decide to rely on third parties to assist them with fraud detection. And in this case, they have to put in place appropriate contractual protections with these data processors. Finally, it's important that companies ensure that data is collected in an accurate way, because inaccurate data may indicate the presence of fraud. The last case study covers affiliates. Operators have an interest to advertise their services on the affiliate website, and in return, the affiliate is paid for every player that comes from its website to the operators. But there are different types of arrangements with affiliates, which depend from the nature of the processing they carry out. For example, if the affiliate is getting a fixed fee to advertise an operator, parties are not sharing any data, and therefore each party is responsible for its data privacy compliance. Another case is when a fee is paid per number of customers redirected or revenue generated for the operator. In this case, affiliates most likely will not need personal data of players, but they will need to get information about the number of players or the revenue generated in order to verify the payment of their fees. For these purposes, operators should share fully anonymized data or pseudonymized data in a way that makes it impossible to identify individual customers. In this scenario, affiliates and operators are independent controllers, and they will not share personal data. Another possibility is that the operator pays the affiliate to send its marketing material to the affiliate's customers. Also here, both parties are independent controllers, which means that each is responsible for their processing operations. This means that the affiliate will have to make sure that it has consent from its customers to advertise third-party services. So, I give you an overview of the code. We talked about measures and the contents of the code. Now we'll talk about the next steps. The first step is the approval process. In order to ensure that this code is effective and that it will have an actual impact on how the sector operates regarding data protection, we aim to have the code formally approved by data protection authorities and also monitored and enforced by a monitoring body. First of all, it has to be considered that this code is a transnational code, which means it applies in different member states. So the approval process is a bit more complicated. The code has been submitted for formal approval to the Maltese Data Protection Authority, which is called the IDPC, the Office of the Information and Data Protection Commissioner. We identified the IDPC as the competent data protection authority by following the factors outlined in the guidelines of codes of conduct published by the European Data Protection Board. These factors were, for example, the location of the largest density of the processing activity or sector, or the initiatives developed by a supervisory authority in a specific field. And the Maltese gambling regulator, the MGA, issued guidelines on data protection for the gambling sector, collaborating with the IDPC itself. Just to be clear, after the submission, EGBA has no control on the process, and the approval process will be managed completely by IDPC and the other data protection authorities. So now I will talk about how the process will work. First of all, together with the IDPC, a maximum of 2 other data protection authorities will co-review and assist the Maltese with the substantive assessment of the code. This will be on a voluntary basis, so we don't know yet which these data protection authorities will be. After this, if the IDPC thinks that the code can be accepted, it will send the code to the European Data Protection Board. This is the body at European level that deals with data protection. The European Data Protection Board will issue an opinion on whether the draft code complies with the GDPR. The IDPC will take this opinion into account and decide whether to approve the code or not. The process is estimated to take 18 to 24 months. This will depend from many factors, like the workload of the IDPC, or if there may be need to amend certain parts of the code, following the feedbacks of the authorities. Finally, the European Data Protection Board, after the code is approved, can even decide to share the document with the European Commission, and the European Commission may decide to give to the code general validity to all EU. In the next slide, we talk about monitoring and enforcement. We drafted into the code some clear requirements which are mandatory for its signatories, and some best practice requirements which are not mandatory. The monitoring of the compliance with these requirements will be assigned to an independent third-party monitoring body. We identified Scope Europe as our monitoring body. This is a company that has already experience on this, since they will be also the monitoring body of the European Cloud Services Code of Conduct, which is another code also in the process of getting approved by the authorities. Finally, the code will be applicable and enforced only after its approval by the authorities. But after this, it will become legally binding for its signatory. The next slide, we cover the next steps for EGBA. First, we will liaise with the IDPC and other data protection authorities during the approval process for the code. This will probably require some back and forths with the authorities, which will give us feedbacks and comments on whether the code needs to be changed or improved. We will also promote the code as we're doing in this webinar. We will present the code in another webinar to the wider gambling industry, especially to other gambling companies that may be interested in adhering to the code. And finally, we will also give external presentations. We will present the code, for example, to the relevant data protection unit in the European Commission. This concludes my presentation. Thank you very much for listening.